it goes to the U.S. Supreme Court. The U.S. Supreme Court says, no, that's wrong. You know, commercial is only one factor. And the court said that obviously, the court ruled in favor of Two Live Crew and said this was protected parody. This was fair use because it sure was commercial, but it really wouldn't. This song would not substitute as far as in the market. People would not buy this instead of buying Roy Orbison's version, so it really wasn't competing. Although they did say maybe it might have wiped out any sort of rap version of it. In fact, they actually sent it back to sort of determine whether or not it might. In fact, ultimately they just dropped the case. But anyway, and the court made it very clear that you have to use the heart of the song, which is what they did. They used the heart of the song to conjure up that image, but then they transformed, it was transformative, and they created something new with new words, and so therefore it was in fact parody, protected parody, fair use. So, but what that case is important is because the court said just because you're trying to make money on it doesn't mean it can't be fair use. So that can have wide applicability in all sorts of situations. Because the appellate court had said it's commercial, therefore it can't be fair use, and the U.S. Supreme Court specifically rejected that idea. Okay. Other questions? Yeah, it's 4:30 on the nose. Amazing.
James, are you familiar with the M&M suit against Apple?
Yeah. Now that has nothing to do with copyright. I mean, it's just the fact they were negotiating to use some song in a commercial, and apparently Apple thought they had the agreement, and apparently they didn't. So I don't know exactly what's going on.
I thought it was a copyright issue.
No. I mean it is, but I mean it's just a matter of whether or not they had been given permission. And often they're not arguing parody or anything of that nature. Just a matter of whether or not that they had an agreement that they could use the song or not.
So even though my understanding is that the Apple commercial showed a teenager listening to his iPod and singing one line out of.
Oh, okay. Well, so in other words, it may end up maybe Apple is arguing fair use. I mean, but what I originally saw was that they had been negotiating.
They had been negotiating.
Okay, so you maybe so that could very well be what it ends up being.
So I can see. I don't know which way that one will fall,
right,
given the criteria you've laid out.
Right.
Because of the commercial aspect, that would be a strike against Apple, but their significant change from the original. Nobody would mistake a kid singing along with what he's listening to the original word.
Right. That's true. But then the argument would be, well, look, obviously Eminem. But I think Eminem wanted like $100,000 or whatever for the use of those three measures or whatever. And
yeah, I think it was in millions.
You may have been. Yeah, I think you're right. I think it was more like $10 million. I think eventually they had settled on another song for $100,000 or whatever. I don't know. But anyway, yeah, that's an interesting situation. But with music, it's really difficult because often there are only ever how many. I mean, music you have to when you put all these notes together, and obviously song you really do have sort of the heart of song. You recognize song because of certain beats and certain measures, the way the music is put together. So that can be really difficult. But in fact, in the thing with George Harrison, there was no evidence that George Harrison consciously copied the "She's So Fine," but the court ruled that because that he had heard that beat and heard that those measures so many times that he sort of subconsciously copied it, and so he was found in violation of copyright law because he sort of did it. He didn't really mean to. He just did it, subconsciously, which is sort of strange. So who knows? Any other questions?
I have a question about library materials. It does talk here about section 106 about lending items. That's prohibited.
Yes, exactly.
Yet, of course, the libraries do that, lend copyrighted materials for use. Is there a limit on how those materials can be used once they're checked out of the library? In other words, could a consultant go in and check out an expensive video that the library's purchased and use it for profit?
Well, I mean, you could use it, I mean, I suppose
Is
in
there a
your,
limit to what you
it-
can use it for?
well, yeah, I mean, obviously there would be a limit. Now, the library wouldn't be liable for any of that. But I mean, just like anything else, you check out a library. I mean, I check out books in the library all the time and maybe use them in some research. But it wouldn't be any different if they used too much of them and didn't give credit for it, you know, and on and on. I mean, so it just depends on how much they used. But obviously, a library has every right. Obviously, a library, obviously under copyright law, the library has a right to. I know the Digital Millennium Copyright Act of 1996 talks a lot about you know, gives libraries a sort of help there and not being sued when their patrons use material illegally. And of course, under the original law, that's why at photocopy machines, if you have up there, you know, have whatever section, whatever it is, posted up there, then the library is not responsible. And that's all part of the statute to give. And of course, library. Also, it's interesting that the law, the original law, I think, gave libraries the right to maybe archive one copy of material. The new law says you can do 3 of them, I believe. So that you can do 3 as opposed to 1 archival copy. So all that stuff, and often I have not stayed up to date with the arcane library stuff as much as I have some other things. But that, I mean, often libraries have to be very concerned about that and all the digital copy, the digital copies of things, and you know, you have to, just as long as you make your patrons aware of the law, then what the patrons do, really, you're not responsible for.
Well, I wasn't concerned so much with copying materials that you checked out of the library, but just if you use them.
Well, that's what people do with library book stuff,
then
right? Is to
copy.
use them.
So you can use them out.
Well, I don't really.
Like a video. Let's say
Well, you couldn't. Yeah, you couldn't. I mean, we just like copyright, whatever. If the person used a certain amount and then got sued, he would have to argue fair use. And you just go through all the same things. It was just like anything else anybody would do. In fact, he got it from a library, sort of irrelevant. Would be my.
that would be considered a legal copy. You checked it out. From the
Oh,
library.
I see.
You
Oh,
checked it
I
out
see
from the
what you
library and
mean.
used it.
Oh, yeah.
Showed the entire video. Like, let's say you checked out
Well,
3
in-
women from the library and then used it in a training program.
Well, no, not a training. No, because Section 110 it only applies to classroom. So if you use it in a classroom,
But that's talking about educational
right.
institutions. Because
So
that's
Section
saying-
110 only applies to classrooms. So
But then
that would
again-
not apply. So those type of things would not apply to other types of training situations.
Like a Caterpillar.
Right. In other words, you could not. So you cannot. Caterpillar can't use Section 110.
Right.
Section 110 is not applicable to Caterpillar.
But could Caterpillar check out the video, Pretty Woman, from the library without buying a copy, use it in a training program? the entire
Probably, yeah.
film,
I think they could.
and-
I think
and
they
then
could.
return it to the library
Yeah.
without making copies.
Right. Yeah, I think they
Make
could.
a profit off of it without paying for it.
Well, I think people already do that a lot already, so they have to do it every time they did it. If they wanted to check it out and use it. So I think that's a good. I mean, here again, I mean, I shouldn't say absolute. So I mean, don't take that to the bank. But I would think they would be able to. I mean, that's what people do. That you. Taping things off of television, it is for personal use. Clearly, I mean, the courts have ruled that it's only for personal use. So if he takes something off of TV and uses it in his video, in his stuff, he's in trouble. Same with even a professor does that, could have problems too. If you videotape something off the History Channel and then you start using it in your classroom, you've got trouble, particularly since you can buy those from the History Channel. So that's certainly, and we all do that. Take that out, would you?
Can I get a copy of that?
But yeah, now I see what you mean there. Yeah, I think they probably could use it. You know, they take it and you don't have any limits on what they can do with it as long as they don't copy it,
Okay.
destroy it. They bring it back to the library, and that's what they do. So that's probably yeah. I see what you're meaning. But obviously 110 wouldn't apply to them. Other questions? Thank you very much.